I'm going to make this brief, but it took me over 6 months to figure out this guy's resume because it's complicated and it's not intuitively obvious. So he's a lawyer. That's pretty easy to understand. But he started off at the high end of that spectrum, right? Like what you would think, where he went to an Ivy League school, got a law degree from the best law school in the United States of America, and then went to Wall Street. He then ended up getting somewhere in the middle of this, and I'm not exactly sure, both an MBA and an MFA at the Iowa Writers Workshop. Some of you might know about that writing program, one of the most prestigious creative writing programs in the world, really. People come from all over the world for that. Something in there about divinity school, and then he ended up at Harvard Medical School as an assistant professor of medicine. I said Harvard Medical School, not the law school. And he spent 5 years working at the highest level of academic medicine, was published in all the major medical journals. He left the ivory tower, climbed down the stairs, came over to California, and now he's working for us to help one-off practitioners who want to come into functional medicine and want to make a career of this with a legal strategy that's going to be defensible, that's going to make you feel like you are confident and can go out and conduct your business in this world as a healthcare practitioner in this space without exposing yourself to undue risk. So I'm going to introduce Michael H. Cohen here.
So tonight I'm going to talk about 2 key mistakes, 4 big questions, 5 risk management questions, 4 legal strategy areas. It's starting to feel like Passover a little bit. And I'm going to give you 0 BS. And by the way, I want you to know, you're going to get knowledge and power, and the entire talk is gluten-free. And also, because I'm a lawyer, I want to give my disclaimer, statement has not been evaluated by FDA. Let's take the big picture. The healthcare market, over $4 trillion. There's a lot of business. There's a lot of ways to help people. At the same time, there are huge areas of risk. Just to speak about physicians, and I know I'm addressing an audience with nurse practitioners, chiropractors, acupuncturists, many other kinds of practitioners. Just looking at the almost 500,000 physicians, 20,000 over a 4-year period were disciplined, and 5,000 lost their license. And if we talk about HIPAA, the largest HIPAA penalty, $4.3 million. That's a big penalty. Now, I'm going to talk about 2 key mistakes. So the first key mistake, does anyone recognize this quote? Does anyone worry about this, the universe expanding? Well, in Woody Allen's film, Alvy Singer, he was worried. He wouldn't go to school. He was a kid. His mother sent him to a psychiatrist, and she said, "Why won't you go to school?" Because it's futile. The universe is expanding. And every day it continues to expand. And his mother said, "Alvy, you live in Brooklyn. Brooklyn is not expanding. Go to school." So Alvy was worried about the wrong thing. And this is what a lot of clinicians do. They're focused on one little area, but meanwhile they're not aware of the other areas of legal risk that can come at them and take a little shark bite. These are the things that you should be worried about. Attorney General, District Attorney, Medical Board, FDA, FTC, other government agencies. START, how many people have heard of it? Intellectual property issues, malpractice, plaintiff trolls, the third-party plaintiffs that can come at you for copyright violations, trademark violations, things you haven't even thought about, things in your business contracts. HIPAA we talked about, telemedicine, fee splitting, anti-kickback, insurance fraud, the list goes on and on. Unfair business practices. Plaintiffs love to add that on. False advertising. Okay, now back to the divine feminine. That was the wrathful feminine. Key mistake number 2. The second key mistake that people come to my law practice, my law firm with, is they've gotten some advice somewhere. They heard it from a friend, who heard it from a senior colleague, who heard it from somebody else, who got it from good authority, from their lawyer, who told them this. And the formula goes exactly like this. I was told that as long as I do blank, I'm okay. Have you ever said that to somebody? Right? I see some nodding heads. As long as I do blank, I'm okay. Substitute your theory du jour, your hypothesis du jour. I heard one the other day about Medicare. You don't violate Medicare. He's a cardiologist if you do this, this, and this. But the minute that he takes out his stethoscope and he puts it on the patient's chest, boom, suddenly he's violated Medicare. I've never heard of such a thing. There's no way to research anything, quite that hypothetical and abstruse. It's a total myth. It's hearsay. So don't base your legal strategy on hearsay. That's the second key mistake. Let me tell you a story about a client of mine, Dr. Seymour Hart. Seymour grew up in a very poor household, and he wanted to make a difference. He saw a lot of suffering around him. So he grew up, he got some student loans, he went to medical school. And finally, he got his certification from IFM, and he opened up a very successful practice. And he joined the staff of a local hospital where he was very, very successful. He left that, and I've got the order backwards, but in essence, he built a successful functional medicine practice. He was very happy. And he was having some financial success, but not quite enough to pay off that mountain of student loans. So he's struggling. And there were a few legal sand traps that were waiting for him. And shortly after all of this success, he hit the wall. He had forgotten to have a lawyer review his employment contract, so he got to his practice, and there was this really nasty non-compete. And he started getting demand letters from another lawyer, and he was very distressed. Then he got hit from Medicare for double billing because he had a concierge practice, and he hadn't vetted the Medicare issues. And third, he didn't know the difference between electronic prescribing and telemedicine rules, which actually required him to be licensed in the remote state. So he didn't know anything about telemedicine. He was also prosecuted for false advertising. He didn't think he'd done anything wrong. All he did was take the advertising company copy that another company had put on its website and put it on his own website. And he got investigated by the DA. And he also got sued by one of these plaintiff troll law firms. I'm a lawyer. We call these other lawyer trolls. Now, Seymour Hart, he's an amalgam of several different clients. Any one of these is enough to fell a practice. One can be enough. And these are real stories. They're just examples from the myriad of possible issues out there. And you can lose it all in a second. And it's always better to have preventative lawyering. It's better to go see a lawyer before, just like going to the dentist, just like having good nutrition. You want to have your legal checkup, have the green juice, get the inoculation, get the good vitamins, get showered with good legal phytochemical nutrients, right? All of that is true. So as they say in Dragnet, the stories are true, the names have been changed to protect the naive. Dr. Hart resolved that he would detoxify himself from bad business practices and identify and address the root causes of his legal ailments. He was overworked and burnt out. He set out on a journey to find someone who could teach him business as an integrated, holistic system, not a response to an isolated set of symptoms. He found that one person who could teach him about a functionally integrated curriculum, teaching him business strategy, operations, marketing, and patient communications, and much more about the business side, because he realized he was wearing two hats. Hat number one, the astute clinician. Hat number two, the business person. And the business person had a lot to learn about business strategy and a lot to learn about legal strategy. And he no longer wanted to learn the hard way. He wanted to learn through education. And the fact is that our society is experiencing a sharp increase in the number of healthcare practitioners who suffer from complex, chronic legal illness. That's why I want to take a holistic approach. That's why I want to address all the threats. Does that sound familiar? I just lifted it right out of the IFM website, and I just substituted law for medicine. But it's really true. You want to look at law in terms of the root causes preventatively at the whole system, not after the fact, not with litigation, not with when the board comes after you for something. So this is what I've devoted a great portion of my career to, whether it's been teaching at Harvard Medical or publishing in the Annals of Internal Medicine, other medical journals, law reviews, getting my own grant as a PI from the NIH. So I've actually been, not on the medical side, but I've been very closely intertwined with medicine for a great deal of my career. And in my law practice, we represent physicians, nurse practitioners, all sorts of practitioners, also businesses, entrepreneurs, maybe your private labeling and brand of supplements, other issues there. Lots, mobile medical apps, wearable technology, AI-powered products, right? The future is all coming to the practice. And this is what we look at. We want to eliminate legal disease. And when we do that, we ask 4 questions. First question, what legal challenge brings you here? What does that sound like? It sounds like what you'd ask a patient, right? And secondly, what outcome would you ideally like? If I could wave a magic wand and it could all go away or it could all line up, what would it be? And thirdly, what have you done so far to solve this? And what I find is that a lot of people have spent a lot of money on lawyers. How many people have spent a lot of money on lawyers? How many chasing the wrong thing or not getting answers? All right, well, I need to meet all the great lawyers out there who've given you great advice. But a lot of people, they get the wrong advice because they don't have specialists. And last, what will it cost if you don't solve this puzzle? And so a client recently answered this: fines, jail time. So they answer these 4 questions so we know what's at stake. And the first thing we talk about is this: you cannot stop the universe from expanding. You cannot eliminate legal risk. The answers are not binary. They're not dichotomous. You're not asking for yes or no. What you want to look at is everything that goes into risk management and risk mitigation. So what's the magnitude of the risk? What could possibly go wrong? How heavy could it be? Are we talking about loss of licensure? Are we talking about a huge penalty, a huge fine? What's the likelihood that it's going to happen? What's the benefit of your proposed approach? And what's your risk tolerance? Just to pin on that one. So a lot of clients come and they say, well, Uber did this, right? Well, you're not Uber, right? If you're in practice, you're not Uber. You just don't have the bandwidth. So it's important to be realistic and look at your alternatives. And that's where the strategy really comes in, to find out what else you could possibly do. So what we try to do is to have business strategy and legal strategy aligned so that the whole package makes sense. For example, if you're dealing with operations, think about HIPAA. Think about privacy and security. Telehealth. If you're talking about marketing and sales, membership versus insurance models. Patient communications, consent forms. What do your consent forms look like? And some of the questions that arise are things like, if you're doing telehealth, do you have to be licensed in the remote state? How many people have like an online coaching program or a practice that reaches across all the states? So this is a big question. Do you need a license in that remote state? When do you need it? Do you need to have a good faith exam? Do you need to see the patient in person? The laws used to say you need a face-to-face exam. Well, what's face-to-face when you have FaceTime? What does that mean? Lab test, prescribing. Are you doing health coaching? Can you just remove your physician hat or your NP hat and call yourself a coach? Big question. HIPAA. Are you under HIPAA? Do you think you're under HIPAA? Maybe you are, maybe you're not. Maybe you just signed a business associate agreement electronically, so you don't think you're under HIPAA because you heard it from a friend, you heard it from a friend who talked to a lawyer who said that as long as you're not, but you might have signed something, so you might be under HIPAA. Do you have privacy and security systems? If something goes wrong with a patient, or if, let's say you do a really great job with a patient, but their physician gets jealous because you did such a great job and had a good outcome, and they complain to the board comes in, now they open up the kitchen sink. Now they're going to look at your privacy and security practices. And it's really important to have everything locked down. Right? We were just talking at dinner about that. Somebody who went through an investigative process, and thank goodness they had locked down these other systems. Okay, membership versus insurance, Medicare, obviously a great conversation starter at a cocktail party. Do you have a membership agreement? What goes in your membership agreement? Is it just like a gym membership, or are there special things that you need to put in? Consent forms. Do you talk about the risks, the benefits, and the alternatives? What's your level of protection? Are you providing primary care? Are you more in a specialist role? So these are just some of the questions that we want to drill into. The important point is to raise them and to understand that when you talk to a lawyer, it's like talking to a really good diagnostician. Their job is to issue spot and then help you mitigate risk and to put these protections in. So just imagine if Dr. Seymour Hart, what if he'd read his contracts before signing them? Amazing, right? What if he had legal review of their contracts? How many people have signed contracts without having a lawyer review them? That's like self-diagnosing, right? So that's a big no-no. Expanding through telehealth. What if you could expand your brick and mortar practice? Let's say you've got a specialty area and you can reach all of these people nationwide. And what if you could do it in a way that's more legally sound than just kind of throwing something on the web and worrying about it later? It's not a good idea to ask for forgiveness instead of permission when it comes to the law. It's better to figure it out. What if you can handle your Medicare issues? What if you've got great consent forms? I was literally talking at dinner to somebody who had this disciplinary issue, and I'm not going to say the name, but the state had combed through his consent forms, line by line. And one of the things that we lawyers do is we're good at crafting language, a sentence. You know, one sentence can stand between you and the cliff. It's got to be a good sentence. So what if he managed his legal risk? Imagine how happy he'd be. He wouldn't find himself, after all the loans and all the hard work and all the study and everything that you all go through as practitioners, and all the angst and all the late night calls and the texts from patients and people sometimes listening and then you celebrate, sometimes they don't, all of this, and then having the legal strategy line up. So the practice itself, it has a good foundation. Just imagine, he'd be very happy, or she, and would probably fold her arms and have that pose. That's my message. Thank you very much. Great to talk to you.